All right, well, so right here, I just want to learn. Welcome, I'm Josh Fairfield. This is Contracts. Happy to see you today. We will usually start 1 minute later. I know this is the last time that you'll all be here quiet right before class starts, but we might as well take advantage of it while we've got it. There are a few things that we'll talk about as we get going in the class. I first of all want to just make everyone aware that we're doing a different recording system. The general camera is back there. The problem is that I sound like the parents in Charlie Brown if I come through that system, and that means that it's difficult for people who need the recording later on. So we're trying something different. That's what this is. It picks me up. It doesn't pick you up, so that'll protect your privacy a little bit. If you're seated here, there's a chance, if you're seated here or here, there's a chance that the back of your head might appear in the video at some point, but other than that, not a big deal. These will be placed someplace where you can get a hold of them, probably YouTube. Feel free to ask questions either by email or directly with the videos, and I'm happy to exchange ideas back and forth there. I figured that's a faster way of getting you the comfort that you need, which is that you're going to have the whole lecture available. Now, if I were sitting in the third row and had just heard that classes were going to be taped and made available like that, my next immediate question was, do I need to come to class? And the answer is yeah, for two reasons. One, because the ABA does have requirements for us, and there's going to be a sign-in sheet that is circulating right now for all of you. Your name should be on the list. If it's not, add it. We'll make sure you get added. And because of the requirements of the ABA and AALS, the American Association of Law Schools, we do need you to be here for all but, we'll say, 2 classes. If you have an emergency and you need to come talk to me, it's one nice thing about WNL. We're a small, nimble school, deeply compassionate. We'll take care of you, but I'm going to need to know about it ahead of time if you have some reason that you can't be in class. And the second reason that you need to be here is because, and this is where we're going to start getting into a little bit of the pedagogy of the class and how it's taught, we are a speaking profession. Now, I won't, like, it's kind of funny, you know, I can say, how many of you in the room, like me, are introverts, right? And anyone who raises their hand fails. So, but if you're an introvert, right, the real introverts are like, really, is this class worth it? Like, you know, the Taylor Tomlinson joke, my favorite comedian. So the bottom line is, though, that we are a speaking profession. Your job will be to stand up in front of I won't make you stand up, to stand up in front of a judge or work with a deal team and get other people to come to an agreement that you can live with. And because of that, answering questions vocally and on our feet is very much in the job description. It's the one part of us that, like, you know, AI will never take away from us. So with that in mind, we do a lot of speaking in this class. It's probably sane for you to think of this class as more like your Spanish or French class than anything else. Law is a language. That'll be a major theme of this class. And there's only one way to learn a language. You do not learn it through book study. You only learn it through speaking. And so that is what we will be doing. We will not be thinking as a lawyer, as they all told you were going to get. You will be speaking as a lawyer, because that's actually our job, is to speak and write as lawyers. So with that in mind, 15% of your grade is based on oral discussion in class. It runs roughly something like this. I will have a randomized set of who I'm going to call on any given day. Literally, there's a deck of cards and I shuffle them and I deal 5 out for the day, and then I email those people about an hour before class. The reason for that is if I do it the day before, then people are like, I didn't get the email. I don't have to do the reading. But you do have to do the reading. The reason I tell you an hour before class, though, is so you just kind of have a moment. Like, you're like, oh, I'm on today. I should probably think about what I like and what I don't like about the reading and how to dig into it and sort of have a chance to prepare. And it also does give you a chance, don't abuse it. It does give you a chance to tell me, I know I'm on call today, but I just broke my ankle. Is there any way that you could just put my card back in the deck and do it another day? And that's fine. Don't abuse it. Among other things, don't abuse it, because the problem is that people who routinely do abuse it end up with less participation points at the end of the class, and that can be a bit of a surprise. So the other part of that is, if you think that you would like to talk about something that we're going to talk about today, let me know. I'll be happy to straight up call on you. If you're an introvert and you feel like you haven't been raising your hand, just volunteering in class in general, and so what you'd like to do is actually think about something in advance. I know this is shocking, this is what I like to do. Think about something in advance, have something to say, and then say it, sure, let me know. Like you're like, I've got ideas for this upcoming class. I would like to raise them. Can you help me do that in a sort of friendly, collaborative fashion? Happy to do that. Happy to call on you if you feel like you're being under-called on. One final note on being called on. I have many strengths. Faces and names are not them. I am very nearly face and name blind. I come by it honestly. My father, who was an artificial intelligence professor at James Madison University, told me a story one time that really stuck with me. His deal was he was introducing a visiting guest lecturer to their department, to the chair of his department. Now, he remembered the guest lecturer's name and forgot the chair of his department's name. That's going to be me. I'm going to take extreme measures to call you by name, to get it right. If you have pronunciation questions or concerns, please come up and let me know. I will absolutely get it pulled together for you. The one thing is, please do decide where you're seating, right? If you move around during the semester, I just will completely lose track of the universe. So please do decide where you're seating. If you're seated in the same place, great. I'm going to circulate the same chart we've got today for next class. If you do need to move, please make sure you get that edited so that I've got you in the right position, and that really helps me both remember who you are and make sure that you get all of the participation points that you're due. So with that in mind, do keep an eye on where you want to be seated. If you do need to change it between now and next time, that's great. Just make sure that that's documented so that you get picked up. All right. There are a few other just basic questions about how the class ends up, although I know that this is one of your first law school classes, and this is a lot very early on. But I did want to make you aware of one further thing, which is sort of the monster at the end of the book, as Grover puts it, which is the examination. And this is going to be a fairly typical law school examination, but there are a few twists. The one twist is this, that I have been teaching this class for a very long time, and that I have put every single one of my prior exams on file for you to look at and to use. Now that means two things, because I don't want your first encounter with the law to be mediated with how I think. How people ask questions is often really indicative of what the question is and what the answer is. And so I want you to get past how I frame certain kinds of questions. I will say this, there is not that much law that we have to go through here. I could probably do it for a professional audience. I could probably teach most of what they need to know about contracts in an afternoon. We're going to have to go through it carefully because we're not learning just contract law, we're learning things like what the hell's law. So we're going to have some deeper conversations about that. But given that that's a part of the discipline, what you should do is this. You should use those exams from this week, right? The way that this class is laid out, it's 13 weeks of us getting together and talking about this stuff. Because of that, I can't do what law really does, which is circle back around, right? Like, we're going to take a look at the very first cases, and I'm going to be telling you, yeah, we're not getting to this stuff until like chapter 8, way down the road, but we have to start somewhere. And what that means is that you can answer questions on the final exam after the first week of class. Now, you can't answer all of them, but you can answer 1/13 of them, because that's what we've covered. And so you should be, from the beginning, go read those exams, because it'll do two things. At the end of this week, it'll show you, hey, there are a few questions that I get what he's talking about. The rest of this is complete gibberish to me. And the second thing that it's going to do is if you read through the other questions, you're like, I don't know. Great. Knowing what you don't know, that's the key to wisdom. And so you're going to be able to then listen for the answers to those things that you don't know as you move throughout the semester. Finally, this is not that big of a class. There is nowhere for me to run. I've basically asked all of the questions that I can ask. Like, I'm going to move the names and the things around and some of the themes. And yes, I will ask some technology forward AI question. I know, I've seen me do it. I will ask a bunch of new stuff. Like, the questions will mostly be new. 2 of them will not be substantively new. To encourage you to go through those exams and get in my office hours from the first week, I will reuse 2 questions from those prior, 8 to 10 exams that are on file. they will have the names and the dates and some other things changed. Like I'm not going to be a sort of an easily searchable kind of guy on it, but the fundamental legal questions gonna be the same. Get stuck in. Find the questions you can answer. Find the reasons you can't answer the questions that you can't answer. Come talk to me about why. My office hours, we will need to decide. I used to put them on the syllabus, and every time during the first couple of classes, the class is like, yeah, but we have something else that's been scheduled for us as a class during that period. So we need to decide as a class when we're going to have office hours. That's fine. Also, just come and talk to me after class. Pretty much any time is going to be a great time to grab me. I'm more than willing to meet with you after class. If you need another time, we'll figure that out as well. But the point is that my classroom and my office hours are going to fill up at the end of the semester. That last week before the end of the semester is going to be packed with study groups. So get your time in early. It'll help you in your participation because you'll be able to understand things and then bring those conversations back into class. And if we've talked about something outside of class and then you bring it into class, that's full participation. Great, love it. Because if you had that question, bet you about 35 other people in the class did as well. So do that from early on in the semester, read the exams, figure out what you know on an ongoing basis, figure out what you don't know, come ask me about it, and we'll work on that. There is one thing I cannot do with the exams, and that is the thing that you will first be tempted by, and then at least two of you will be obsessed by the end of the class. Don't do it, which is we cannot go through and I cannot give you a precise model answer to each of the questions. There's a specific reason for that, which is every legal question has a wide range of answers or we'd be out of a job. The question to every, you know this already, the question to every legal question is, the answer to every legal question is? It depends. Right. What are we doing here? We're learning it depends on what? And to have a coherent and strong response to that. That's what I'll be grading, is your response coherent or strong? It's not, do I agree with what you said? It's not, is this checking the box multiple choice correct, which is a disastrous way to run any kind of thing, and will usually, and despite the fact that the next gen bar is moving in that direction, will not be a thing in 10 years because that is the kind of test that AI instantly memorizes, and it's a crappy test. It doesn't really test, like who goes out into practice and does multiple choice boxes? That's nuts. But for now, my exam is going to be as close to your real life praxis as you can get. That is, you'll get legal questions. Some of them you won't have seen before, and you're going to have to give me an approach based on what we've learned as to what you're going to do with something you haven't seen yet. That's what the practice of law is. All right, that's a lot. We're at 1:12 past the hour. Studies show that after about 7 minutes, like you just can't hear my voice at all anymore. So one thing that we will do each class early on like this, we'll do a trial run right now, is we will flip the class. We're going to start class with questions you've got from the entire class up till that point. Some classes do review sessions at the end of the class, at the end of like the last week of class. We will do some of that. We'll have dedicated review sessions, but we're actually going to do it the whole semester so that we spend a significant period of time with you asking questions, stuff that you don't understand. The reason that that's important is because I find with law students, the hard part's not learning the answers. The hard part's learning what's important and is an answer. Like, what am I even looking at here? What do I pay attention to? And that's why we're going to flip this so that you'll have lots of questions early on. I'll answer them. You're just going to play Stump the Chump. You won't be on. You will get full participation for asking questions. So, you know, like if you want to know something's on the exam or if you want to know something's important, ask. If you want to know, hey, we looked at this case. What do you want us to know from this case? Ask, I'll tell you. All right? That kind of stuff. Then we'll move on into the meat of the class. A final note on pedagogy, and yes, I'm lecturing a lot, and yes, this is the last day that I'll do it, but you know, I didn't want you to come in cold and be like, okay, now let's start talking, right? But the last thing is, you will have noticed the technology policy, and that's a little weird because I am our Director of Artificial Intelligence Legal Innovation Strategy. I'm probably the person you need to come talk to if anything informatics, cryptocurrency, technology-oriented comes across your radar. Why then is it that I've asked you not to bring laptops, tablets, or their equivalents into class? And there's a range of reasons, but the bottom line is studies show, and they really, really do, that the purpose of these processes is not for you to like create a list of answers to questions that you know are going to be asked. It is for you to create a mind map in your mind of how this subject matter works and how these fit together, so that in 5 years, when a young associate asks you a question, you'll be like, I don't know what the answer, but this is what the answer's gotta be. I can just tell from the structure of this and from what I learned in class. Go verify that I'm right, but I'm right. And second of all, if any of you are worried about losing your jobs to AI, no, you're not. If any of you are worried about losing your jobs to AI, this is the very technique and competence that will secure your job against it. That is, Wired magazine, of all people, and a few others this past week got nailed because they published a bunch of articles by Margot Blanchot, I think the name was. AI-generated crap. They fell for it. The reason that they caught it was not because there were M dashes in it, and stop, just miss me with the stupid, easy AI detection. All that's done is removed M dashes from our writing, and I loved M dashes, and now I'm just like lost. Actually, I'm putting it in my new book. I'm putting it in there. I'm like, no, I'm gonna use M dashes. I promise you I haven't used AI to write any of this. But they found it out because the stories didn't fit together, because it wasn't making sense when somebody drilled down on it. And by the way, that's what we're finding in all these cases. I am actually, at the present time, involved in cases in which the other side has largely, and they shouldn't do it, but has largely punted their attorney's work to artificial intelligence. And it all looks really persuasive on the surface. It all looks like it makes sense. You have to look down and be like, wait, whoa, that's not how any of this works. Like, they're invoking this statutory regime, but it's like, we'll practice, actually. They're invoking the Uniform Commercial Code, but I'm noticing that this is a contract for services. The Uniform Commercial Code doesn't even apply. Why are they even mentioned? You start to dig down into that process, that systems kind of analysis, and that's where our skill as a lawyer comes out, and that's why AI will never take your job. I mean, it will never take your job. I am dead serious of that. There's so much hype out there. I'll show you how to use it, but man, not for replacing what young associates do. Not a chance. All right. The second thing is, what happens is, when you are using technology, studies show that you go into what's called stenographer mode. Your mind becomes a conduit between what I'm saying and your fingers, where you're trying to capture and record everything that's happening in class. That's what that's for. That is not what you need to be doing. You need to be taking notes, not because they are a record that you will need for later, but literally because the first pass through your mind, where you're taking the big things we're talking about and reducing them down to points that you are recording, is a critical first pass for moving the information into your mind and for creating the kind of mental map that we need in order to do this work. The same thing goes for your outline at the end of the class. Do not use AI to create your outline. Now, that is utterly unenforceable. There's not, like, I'm never going to see your outline unless you show it to me. I'm certainly not going to check it for AI. You know, your exams, yes, but your other stuff, no, absolutely not. So why would I say that? I would say that for the same reason that I would say it's also a huge mistake to not create an outline, and then at the end of the class to go buy a commercial outline or to go look for one online. I've been teaching this class for a very long time. There are perfectly good outlines out there, just for download, that cover a lot of my classes. Go ahead, use them and use AI, but later in your process. For the same reason, the purpose of an outline is not to create a document that you're going to somehow like be relying on in the exam. If you're doing that, I have screwed up. You should not have time to be looking at page 73 on your outline. Like, go ahead, create the outline, make it hashtag searchable. I'm serious, so that you can move fast. But don't for a split second think that what's going to be happening on the exam is you're going to be like, here's the question, let me go look at my outline, here's what I need to say, let me come back here. You will not have time for that, and the exact questions that we have talked about in class will not be the questions on the exam. So it's not going to help you in that sense. What it will do is it will create a mind map. Outlines are mind mapping technology. They are social technology that have been adopted in law school to help you create a structure. For those of you, and this is a huge weakness in my work, I am an auditory person. We will be talking. For those of you who are very visually minded, right? Let's just try it. Let's just try it here. Let's find out who you are. Everybody shut your eyes. Everybody think of an apple. Raise your hand if you see, nobody else can see because everybody's eyes are shut. Raise your hand if you see absolutely nothing. Raise your hand if you see sort of a faint gray ghostly outline of an apple. Raise your hand if you see an apple like it's on a movie projector in front of your face. Holy shit. Get your hands down. Fantastic. What that means is I got to step it up. There are a bunch of visuals in this room. By the way, very strange. I see the ghostly stuff at best. Some people see absolutely nothing. They tend to be wizards with words, but also they wonder how people can draw. How is drawing even? Like, I took art lessons with my oldest daughter for years. That's why I went to law school. For those of you who do see like it's an apple, like it's a movie in front of your eyes, I will try. But also, you need to be aware that there are other visuals. One of the things that we're doing here is we're creating a visual record of this that may speak to you in some better ways. I will also try to use gestures, sometimes pictures, to get that through to your learning style. But you should be aware of that in whatever you're doing. But for those of us who are largely word-oriented, and as lawyers we're going to be heavily word-oriented, this is mind mapping software. If you're visually oriented, use different mind mapping software. Your outline should be visual. There should be flowcharts. There should be decision trees. There should be images that are going to leap into your brain and help you learn that stuff. The outline is not for the exam. It is for your brain. Don't skip it, or you'll skip doing the work of creating the framework in your mind of what contract law is. And also, I think it's not a great discipline overall for the class. All right, so I said we were going to prepare. This has been a lot. I don't know if anybody has any questions, but I will now just say, does anybody have any questions about any of this stuff, anything about the class whatsoever, before we begin to dive into contract law? Yeah? You said there wouldn't be a decisive answer for any of the questions. Are there example answers? There are not. Perfect. And that's because understood. I need you to consider and we'll get into this. The point of the study of law is the study of the questions. It is not the study of the answers. The answers change every Wednesday. The questions don't. And so getting to the relevant question, you'll often find a question, and if I've done my job right, like any lawsuit's like war. Both sides are fundamentally wrong about the strength and commitment of their opponent. That's what goes to court. Because if somebody's clearly right, if the law is clear, that's not a lawsuit. That's a settlement. At most, the parties are going to settle. Probably they're not even going to bring the case. So because of that, I will often pose questions that will create a fork in the road. What I need you to do is identify the question and then say, if it goes this way, that's the answer. If it goes this way, that's the answer. I read Getting to Maybe. I know the fork. You know the deal. Yeah.
So this question has a couple of prongs. In the syllabus that is recommended, we get a statutory supplement.
Yes, please. Thank you for raising that.
Yes. A, what is that? And B, where would that come from?
Cool. So the bookstore got caught by surprise this year because the statutory supplement I've used for years has, for reasons that you will discover in intellectual property class, or maybe if I get going on a rant, a lot of these publishers have tried to move to fully electronic texts, which I think are profoundly problematic, not because electronic is bad, but just because in the study of law, the ability to flip one page to one side and one page to the other side and see the context and framework within which you're operating is pretty killer. So this is a statutory supplement. There are a bunch of other ones. All I need is one that has both elements of law that we will begin discussing today. That is, it needs sections from the Restatement, Second of Contracts, the Restatement of Contracts, and Uniform Commercial Code, at a minimum, Uniform Commercial Code Article 2. If your contract supplement has the Restatement of Contracts and Uniform Commercial Code Article 2, and is from like the past 5 years, and if you have to push it, closer to a decade, you're fine. There's one on file. They give you an electronic copy when you buy it, but then they want to be like, and the bonus is you get a physical copy if you pay even more. I wish them the success of that business model. There are also just lots of these floating around the law school because most contract classes or sales classes, upper level classes require them. Secured transactions requires them. Any UCC class will require them, so there's a bunch of them around. If you absolutely can't find one, this one's from 2018, 2019, hit me up after class, I will give you this one. There's a bunch of, I have a couple, I don't have many, but I have a couple of them that are from the past 5 years or so that are perfectly coherent. Thanks for asking. You do need one. And work with me. If you can't get it cheaply and sanely, work with me. I'll help you find one. But you do need one because we're going to need to be looking at the code, looking at the restatement of contracts. And when we pull these provisions up, it'll be very important for you to have something that's actually got the text of what we're talking about. And the book doesn't have it. It's fairly standard for books not to have it. Good question. Yeah?
So on that, I already bought the electronic version.
Great. Nope, print it out. We should. Okay. What I'm hoping, legit point. What I'm hoping is, first of all, you can print out everything and put it in a binder, but I would just order the physical copy. But the other thing is that I will try. I am not promising. I will try to continue a practice that I started during the pandemic, which is to send you an agenda before each class that's roughly speaking going to sort of lay out what we will be talking about. And I think you can use that agenda to make that prediction. If you can't, if you're having trouble with it, though, let me know. I mean, frankly, you're a pretty good candidate. I'll just give you this one after class. But we'll figure out one way or the other so that you don't have to worry about it. Okay, cool, good question. Anything further, y'all? All right, cool. Well, then let's talk about contract law. And this is a strange one. We start the study of law with the study of contracts, and I think I understand why, but it's taken a minute because this is a very, very weird one. I want you to think about how hard it is to teach and write a course about contract law. Let's say that A and B decide to sell A's glasses, right? And they decide to sell them for $5, and they decide that delivery is right now. And then legit, so that's a contract. What are the terms of the contract?
That A sell B A's glasses for $5 and deliver them post-haste.
Post-haste, right. Okay, so there's a couple things there. First of all, sale, right? What are some other kinds of arrangements we might have here? I'm going to need those.
Provide some sort of services.
Some sort of services, that's the big other split. What is that? What is that if I just simply hand somebody something? Yeah. Transfer. By the way, what does it take? This is really important because the whole crypto community got super confused about that. What was missing from this to make it a transfer? That's an excellent point.
Payment from B to A.
Payment?
Consideration.
Consideration?
Delivery.
And here we're doing it. By the way, I love this moment, right? So he's offering me a card. This is something that's going to come out in Lucy versus Zehmer. Why is he offering payment? To create the form of a contract, to clarify that it is a contract for sale. Because what else could it be?
A gift.
A gift, right? What else could it be? Borrowing, lending, right? What else could it be?
I mean, if you don't have a contract, you could have just stolen and you wouldn't have record of it.
It could be theft, right? That's where I get hired to do that all the time because somebody has stolen somebody else's cryptocurrency and then they're like, it's mine now. It's like, no, it's really not yours just because you took it. That's not really a thing. You can't do that. All right. So what we're doing here is we're creating the form of the transaction. Right? And what he's trying to do here is establish the relationship of the transaction. Obviously, I will demand the glasses back. He's having swapped them out. It's not your prescription, I presume.
It is not.
No, it is not. And demonstrating to those of you who are in the room that this was probably what the law calls, you don't need to write this down, you'll get it later, a bailment, that is borrowing. I've lent it to somebody to make a point in class. So what we need here are a bunch of these terms. Now here's the thing. We can talk about bailments and da-da-da-da, but what kind of question am I going to ask you in a contracts exam about this contract? Let's try. Question 1. What was the price of the glasses?
$5.
$5. You're on track for an A+ so far. Was this a contract for borrowing, sale, or lease, or theft? Sale. It was a contract for sale. What was the subject matter of the contract? Oh, this is going to be super clever. Hard to answer. God damn it. I do have a problem, by the way. I work blue. I'm trying to get a handle on it. But if you're offended by language, like maybe find another section because it's going to happen from time to time. Do you see the problem? The law of contracts is what? What's the law here? Yeah?
I was going to say straightforward.
Straightforward in the sense that we're going to start talking about the objectivity-subjectivity split, probably the single greatest point throughout the entire course, for reasons we'll talk about as soon as we get to Lucy versus Zehmer. What's the law of can I punch you? No. Why, he says, where does it say that? Oh, criminal statutes, tort statutes, cool. Where does it say that the subject matter of the contract is glasses, that they cost $5, the delivery is today? Where does it say that? In what book of statutes does it say that? Where does it say it? You get to make your own. This is the weirdest class to start learning law from, because the law of contracts is what we're going to do. For those of you who are into the Marvel universe, we're going to create a pocket universe of law. We're going to go Doctor Strange on this stuff. We're going to just create a pocket universe of law in which the rules apply only to us. Now, the no punching rule does not apply only to us. They apply to everyone you ever meet. The rules of don't take people's stuff, that's property next semester. That's not by agreement. That doesn't just apply to you and me. That applies to everyone that runs into the property. No, you may not take my MacBook Air. It is my life. Right? Contract law is a pocket universe where the law is defined by the parties who have written themselves a bespoke, an individualized set of law just for them. Now that means that this is the area where we are at our strongest as lawyers. We can write almost within the bounds of illegality. We can write whatever we want, right? But we do need to understand throughout the course why the state and the apparatuses of state power and theory, largely through a theory by which contracts make us all wealthier and therefore they should be defended, are going to take our private statement and turn them into a matter of public interest, that is enforcement through the courts. Why would they do that? That largely is going to draw on, in my class, the language of economics. And on the other hand, it will draw on the language of moral and promise-keeping theory. There's basically two theories as to why the state should bother to enforce our pocket universe as law. And the one is that trades make everybody wealthier. That'll be a huge theme in the class. And the other is that for an ordered society and predictability, people ought to do what they said they were going to do. And so we'll follow that track all the way down. So when we talk about contract law, we're talking about a very strange kind of law. We're talking about law that is written by the parties, and therefore I can't really ask you on the exam questions about the intent of the parties, questions about what the contract says, because I've got to give you the contract in order for you to answer the question. Instead, what we're going to have to do is step one step further out and talk about what are the rules that enable and generate benefit from this system where people get to write their own law. Because otherwise it's a real short class. What is the law of contracts? Whatever you damn well please. And we've got, like 12 more classes to go, so we've got to come up with a second sentence here. All right. Any questions on that before we get into this? That is, for purposes of this class, we're going to be talking about contracts as the law of bargained for exchange and the law of keeping promises. The one theory is going to be primarily economic. The other theory will be primarily from moral philosophy. We will then take those ideas and say, okay, given that there is a state rationale to get the state involved for enforcing our private pocket universe, what are some things that courts are going to do to establish, and I'm coming right back to you, sir, to establish this problem of subjectivity and objectivity? Has anyone begun to notice the problem of having a judge interpret our pocket universe? If you're into the Marvel whole setup, you could think like the what if guy, the Watcher. He's like trying to interpret what's going on here. What's the problem with having a judge interpret this pocket universe? Yeah. They're subjective. That is, our meanings, what we mean when we speak, is a function, in large part, of our intention. So why not that? Why don't we just have that be the rule of contract law? That contracts mean what the parties intended them to mean.
Because people can't possibly conceive, as you see, Doctor Strange, all these possible externalities and circumstances.
Right. One, the entire idea of relying purely on the intentions of the drafting parties is nonsense on stilts. We will see, I love that point. We will see that when we get to NIPSCO and Article 615, which is a doctrine we will not see for endless ages yet, but it's the doctrine of impossibility or impracticability. It says, when should you call off a contract because something happened that the parties did not anticipate happening? And for people who are worried about losing their jobs to computers, I would invite you as a exercise in taunting your computer to ask it to comprise a list of all of the things that are not on that list. Enjoy. It's something that it can't do. That's what impossibility is. It's literally the list of things that will call us to cause off this contract that we didn't think of, but if we had, we would call the contract off. So one point is the whole subjective intent thing as a broad view is just completely beeping impossible. It's just utterly impossible. But more than that, we can say fine, but close is good enough. Why not, broadly speaking, if we can prove that the parties meant one thing, let's go ahead and go with that. What's the other problem with it? Yeah. People can change their intentions, and until technologists perfect that horrific implant that can tell what you're thinking, we don't know what you really meant at the time that you were entering into the contract. We think you might be lying, or, as is far more commonly the case, you are filling in things you didn't think of at the time with terms that are now to your advantage, given how things worked out after the fact. You can call it lying, you can call it gap filling, I don't care. The problem is the same. Courts can't tell, right? And this really matters. When courts can't tell what somebody means, we're going to have to work toward a theory of mediating. And we're never going to get resolution on this. In a few minutes, we'll start in with some of the cases, and we'll talk about them. And I'll say things like, the objective theory of contract is the dominant theory of contract. And you're going to write it down. I know, I've seen this happen. What I want you to understand is it's nonsense. Even at its most objective, at its most cold-hearted, bloody, absolutely emotion-free objective, it's still fundamentally objective, and I'll prove it to you. What are these worth?
Whatever someone's willing to pay for.
Well, that's the right answer. Whatever someone's willing to pay for them. How do we figure that out? We're talking about dollar bills, ladies and gentlemen. There is the dismal science of economics. There is nothing more boring, more pedestrian, more quantifiable than dollars, right? Purely objective. What's somebody willing to pay for them? Hold an auction, right? We might hold an auction. We might find out that way. What's the one thing you're going to immediately notice at an auction? No matter who wins, we're going to notice one thing about it. Everyone has a different subjective valuation. Crap! There just went our entire objective theory, because even the most objective thing possible, the value of something, is fundamentally subjective. Except, by the way, it's not just subjective either. Look, let's say that he had broken them during my little example. Let's say also that I were a jerk. I probably am a jerk, but I'm not going to be a jerk about this. And so they were broken, right? And I was inclined to do something about it. How would the court determine the value of the glasses in the following lawsuit? Yeah.
Replacement costs?
Yeah, replacement costs. And where would you go find those?
Any iStore?
Yeah, right. Go iStore. Actually, I think these are from CVS. They're still my favorite, but fine. Like, they're going to cost, like, damages are somewhere in the order of $17.99, right? Now, does that truly replace the value of these if these were the glasses that I took with me to Norway with my wife on her 50th anniversary? Would I accept an offer from any of you for $17.99 for these glasses? So let's be clear, your answers are correct, but they do not resolve the problem in any way. What we're introducing here are some major themes of the course. Some major themes of the course are what we will call silos. They will be a part of the final examination on the policy question. A policy question on my exam is not an opportunity for you to tell me about your feelings. It is a way for you to follow a thread that runs all throughout the course. And here we have identified several threads that are going to go all the way throughout the course. The one is the fundamentally unsolvable problem of objectivity, which is that it is made up of subjective intentions, but is also objective, but is also subjective, but is also objective, but is also subjective. It doesn't actually resolve. Oh, by the way, let's say you were the lawyer. The reason that these are silos, the reason I call these silos, themes that run throughout the entire case, the entire class. The reason that we point these out, these fundamental ambiguities, you're going to notice me do this a lot with cases. We'll come up with a case, I'll ask you, what's the law here? You'll tell me. We'll proceed to kick the living crap out of that law, and you'll be left feeling that I have a fundamental hatred of law and judges in general. Not true. What am I doing when I'm kicking the crap out of a legal decision? And I'm going to teach you to do it. Yeah, welcome to the profession. We don't always get the case handed where the controlling precedent's on our side. Sometimes we get handed, about half the time I'd say, the other side of the case. And that's why we need to see what the other argument was. And then you're going to get real confused when I go back and, like, once we've established that other argument in your mind and I've now finally convinced you that the case is completely wrong, we'll go back and I'll prove to you that the case is completely right. Because that's our job. Because that's what we do. We understand the structures of these things and we present our client's case in the way that fits best with what we're seeing here. That's our job. Okay. There's only one rule, by the way, in terms of making an argument that you think is not a correct one in front of a court. And that is our duty of candor to the court, which you have to keep. And the way that you check it, here's my mom's rule. If you're ever afraid to tell another lawyer exactly the legal argument that you're advancing, don't do it. But other than that, we're going to constantly be looking for the ways in which the current framework is right, so that we can use it if we need it, and the ways in which it is wrong, so we can look at the other framework and maybe push that one over the end line sometimes. Of these theories of the class that we're going to use to shove things back and forth, I'll call these levers, because these become tools you can use to win a case by framing it in a completely different way. You could frame it this way, or we could see it this way. And over here you win, and over here you lose. It's much less we're arguing back and forth about facts in court. The practice of law is a lot more what framework does the court adopt? And if the court adopts your framework, you've won the case. I don't care what the opinion says. And so that's what we will do. We will look at one framework and then the other framework, and if we've got time, we'll go back to the first framework again. It's not because all case law sucks and all judges suck. There is one judge you will know I do not like. But throughout this entire, I like the guy just fine, I just don't like the opinions. Also because, anyway, long history there. He taught my favorite class in law school. But it's not that we don't like judges, it's not that we don't like law, it's that our job as lawyers is to invert the argument and is to win no matter whose side we're handed. Okay. On that, our first lever we discovered is subjectivity versus objective, right? This will go actually throughout your entire law school career. If somebody's making an objective argument, you're like, okay, cool, there's an objective argument. I think, yeah, but Your Honor, what the parties actually really meant, and here's the evidence showing that they actually really meant that, is this. And you'll win that case if you can show what the parties actually really meant. If the parties had actually decided that good faith meant payment on every Wednesday, and you've got that email, you will win despite everything that we're about to talk about the objective theory of contract, where good faith just must mean what people in general think it means. Nope. So that's what we're going to do. We're going to use these levers back and forth. Another big lever for the class, we'll just do 2 for now. There will be more as we go through the class. The other big lever that we're going to talk about for now will have to do with economic language. For those of you who've done economics, great, you'll be happy. For those of you who haven't, we'll take it slow. Do not be worried about asking me what the hell I am talking about when I make statements that are coming from economic language. Economic language is not a legal argument. It is very rarely, except when Judge Posner writes, hey, look at who wrote NIPSCO. It is very rarely an express part of the decision-making process. It is, however, the foundation stone of contract. And if you can show the judge that what is happening in a case fundamentally ruins that foundation stone, then you will win the case. The court will adapt the law in your direction no matter what. So let's start with that basic idea, and then we'll get into Lucy versus Zehmer and NIPSCO when we move into the classes. But let's pause here just for a second. Does anybody have any questions about anything that I've gone through? And get used to just boiling down. If I've lost you on a point, tell me to go back over it. Get me to say it again. Anything that people haven't tracked so far? Cool. Here we go. So when we're talking about economic language, we need to talk about a very specific state of affairs that does not always happen. And this can get charged. People come to this with a lot of other priors from their life, other pre-commitments. They come to economic language from all directions. I hope to profoundly confuse you as to where I actually stand on any of this stuff. But I do need you to see a few things about the economic argument and when it falls down. Here's the economic argument. Why do we foster and permit trade? Contract, and this is one you write down if you haven't already, is the law of bargained for exchange. Contracts is the law of bargained for exchange. Why would we protect bargained for exchange? And why wouldn't we protect non-bargained for exchange? Anybody got a crack at it? Why is, and I am not, none of this is true. There's our overarching framework. I'm not doing this. Why is I give this to you not protectable as a matter of contract law, but would you like to buy it for $5? He says yes. I give it to him. He gives me $5. That is enforceable by contract law. I'm not asking as a matter of law. Somebody who's read way ahead, and you know who you are, has already got like consideration in the back of your mind. That's not an answer. We're talking just purely economics for a minute. Why is one form of that transaction completely different from the other, such that one of them is a trick question on the exam? If I just give you the glasses, it's utterly, if I promise to give you the glasses, I hereby promise to give you these glasses as a free gift. Nah, completely unenforceable. I didn't even need to use caveats, right? Completely unenforceable. Yet if we come to an agreement where you offer me $5 and I offer you the glasses, that's actually fully enforceable. I have to use caveats and be on video saying I do not intend to do this, or it's an enforceable contract, as Lucy versus Zehmer found out. What's the difference? Was there a hand? Yeah, go for it.
People have things to lose.
People have things to lose. People have something at stake. That does start to come up. Yeah?
Trade is beneficial because both parties profit and leads to better allocation of resources in the
Okay.
economy.
Trade is useful because both parties profit. This is the idea that I need you to both see, and for those of you who are like, oh man, this is going to be another one of these dry, dismal economics where we're just going to all get, basically the Bureau of Statistics is going to show up and tell us why everything should basically screw poor people over. That's not how this class is going to go. But I do need you to see it. Because nothing's changed, y'all. If I trade, let's try it. Let's not try it, by the way, because this would become legally enforceable. If I were to trade the glasses for the pen that's on the table right there, it's the same glasses, it's the same pen, it's the same humans. How in the hell did everybody get richer?
You really needed a pen.
The subjective fit between my needs and the pen has now been better met, such that the pen is worth more to me than the glasses. Remember when I said valuation, the fundamental economic objective number, is profoundly subjective? Hi, welcome to it. In fact, subjectivity is the basis for the value of trade, the fact that people value things at different. Because if they didn't value things at different, no one would trade, right? That's the whole damn deal. So next time some economist corners you at a party and is like, this is all objective, just no. So, what's then the difference? So, do you see that then? That everybody, now I'm going to use a few words here that are going to come up throughout the semester. I'll try right now to talk about them. When we trade, let's do it now with money. Money's nice because you can see it with pens. I need the pen more than I need the glasses. He needs the glasses more than he needs the pen. That's the reason we agree to the trade, right? But let's start using money because that's going to make another point more clear. What's a cup of coffee cost these days? It's like 10% more every week. Are you fucking kidding? Pardon me. Yeah, right. Roadmap's not that bad yet, but like they're out 11. They're pretty nice. That's out of time. Okay, so $7. Holy shit. But I guess this drives home my point, right? Because I need coffee in order to function. Now, fortunately, I got enough in the lounge upstairs. I made a whole new pot though and drank it. But let's say I need a lot of coffee and I've got a 2-hour lecture, and so I have got to be on point and I've got to be on, right? So I show up and I buy a cup of coffee from Roadmap for $7. Now, we know two things from the fact that that happened. What do we know about the value of the coffee to me? It was worth $7. And by the way, you're right. So the fact that I ask a follow-up question does not mean that you are wrong. Do we know that it's worth $7 to me? It's worth at least $7. What if I am, in fact, this has happened, what if I have just gotten a new video game, Kingdom Come Deliverance 2, for those of you who are interested, and I have been up all night playing it, and so I have got to get the coffee. I might pay $10 for it if I'm that hard up, right? What else do we know? What's the second fact that we know about the coffee and its value?
It's worth less than $7 to the people selling it.
It's worth less than $7 to the people selling it. By the way, I strongly suspect that they'd take about $2.50 for it. I think we're getting screwed, right? And that's why negotiation works and bargaining techniques work, is because there's what's called consumer surplus. This is consumer surplus. The degree to which both parties are better off as the result of trade is a stack of money, and that stack of money gets divided. Let's try it. Let's say they would have sold me the coffee at $5. They've just raised it because they thought it was the cool thing to do because they saw Walmart doing it. And I would have paid for up to $10 for it. What's the consumer surplus? $5. From what they would have taken for it to what I would have paid for it. Now you can move the actual price point between these two spectrums, right? So that I can get all of the consumer surplus. 1 day sale, $5. I get all the consumer surplus. They're just using it as a loss leader to get me in the door next time. They make no money. I make all the money. I go home that day, I'm like, I found a latte for $5. I'm going back. This turns out to be what happens to Blue Ridge Bucha up in Waynesboro when they had free refill days, because I live on kombucha. They had free refill days on Saturdays. If you buy their bottles ahead of time, you can bring their bottles back. I have 19 of them. So I have discovered a way, and they're like, we're going to end the promotion next Saturday, actually. So I will be kombucha-less from that point forward. I'm making my own. So the point here is that I might get almost all of the consumer surplus. Or they may have me completely over the barrelhead, and they may say, $9.75, $10. And I'll be like, okay, but like I have got to be on point for class today, and so I need it, and so I'll pay that. And they could take all the consumer surplus. Economics does not care who gets the consumer surplus. They should, because economic theory has got huge gaping holes in it, as we can prove through experiments with capuchin monkeys, and I'll explain those in a minute. But before we get to the holes in economic theory, I need you to see economic theory because it is the dominant theory behind all of this. It is the reason why the state gets employed to enforce private dimensional agreements. And that is that the state does not care, contract law does not care, whether I buy, let's try one. So if anybody is into collectible card trading games, right? So you might imagine a Black Border, Black Lotus. I actually played back in the day. I had one, I should have kept it. But that's nowhere near the regret I feel around Bitcoin. But let's say that somebody then says, hey, that's stupid. It's crazy to pay $5,000 for a piece of cardboard. The courts will just not become involved with that question. They're like, we do not care what your subjective valuations are. We just care that they're different and that you agreed ahead of time to trade, and we're not going to get into the split. What makes courts sad, and I really need to reframe this. I said it differently for years, and it was sort of an awful thing, so I'm going to try it this time. I'll try a different metaphor. Every time a trade could have gone through, that is, I want the card. You're like, I know, I want to sell you the card. But then because of some other rule, regulation, or cost, we end up not trading. Say, for example, they say, hey, we'll sell you this coffee for $9. And I'm like, great. And they're like, yeah, plus $1.30 tax. I'm like, not great. The deal no longer happens. It would have happened. I would have taken home, even I, the guy who lost in that deal, I still would have taken home 70 cents worth of consumer surplus that day. Would have been happy, right? But if the deal doesn't go through because of other transaction costs, other things that get in the way, then we lose the value of trade. Now, in economic terms, that is called, and this is another one to write down, this is the second one to write down, that is called deadweight loss. Deadweight loss is simply when a trade that would have made everyone else richer doesn't. We will see that in NIPSCO. Every trade coming from NIPSCO is a loss to the universe, which means, I'm going to now coin this phrase a little bit differently than I have in the past. Every time a trade does not go through, God pops a balloon. The world is just a little bit worse because we couldn't get rich for free. We could have all been better off and nobody worse off. That's going to be my final economic point, and we're going to move on. We could have all been better off and nobody worse off. Instead, we couldn't because something got in the way, because some reason the deal didn't go through. Every time a deal does not go through that would have otherwise been mutually beneficial, God pops a balloon, and that is called deadweight loss. Yeah.
Is it impossible to have a sale that does go through and still be deadweight loss because the one party was willing to pay more? Does that question make sense? Is it impossible to have deadweight
Yes,
loss?
for that reason. It is not impossible for other reasons, as we'll see in NIPSCO. In NIPSCO, the court got asked to enforce an agreement that would have cost the world money with every lump of coal pulled out of the ground. The deal was otherwise perfectly enforceable, and Judge Posner's like, not doing it. I'm not enforcing this because, although that takes the form of a contract, it is nothing but loss all the way down. Keeping that mine open, every bit of work they do costs more than the benefit it delivers. The longer you stay open, the worse the universe gets. Not the worse it is for the miners, not even the worse it is for the energy utility, the worse it is for everybody. Literally, we are setting money on fire with every time this happens. And so there are some places where it shows up and where courts then react exactly the way Judge Posner did. They'll route that through legal doctrine. But the point about economic doctrine is it helps you see what they're going to do. Now, the legal words you give them to let them do it, well, that's your skill as a lawyer. But it's often really useful to see what they're going to do. And you can take a look at a case and be like, I know what they're going to do. Now I got to give them the chance to do it. Now, I did promise to give those of you who are like, ugh, this economic stuff, I can see where this ends and it's never good for vulnerable people. I'm going to give you a little bit of relief at this point and say there is something fundamentally wrong with this framework of the universe. Did anybody notice it? When I said I should have taken the deal at $9.30 for a cup of coffee because I would still get 70 cents worth of consumer surplus? There's an old game that works that way, dividing up the profits. It's called the ultimatum game. The way the ultimatum game works is this. You have between $1 and $100, you have two people, two players. One player says, I'm going to divide up the money this way, say 50-50, 99-1. I get 99, you get 1, I get 50, you get 50. First person makes that determination. The second person decides, do we both get what the first person said, or do we get nothing? Now, I want to ask you two questions. When you put humans in the lab, never mind this economics crap, because economics believes in a mythical figure. Along with the Yeti, we have the invisible hand of the market, and we have Homo economicus, the economic person who makes decisions. Let's say that you give me a 99-1 split. So I get $1, you get $99. The economists would say, do I take that deal or not? I take it. Why do I take it?
Take it because you both profit.
Yeah, I get $1, and I'd rather have $1 than no dollar. You put humans in the lab, real humans. I know this is shocking. That's the major problem with neoclassical economics is they don't have the courage to actually experiment on this stuff. That's why behavioral economics is where the bomb is. It's awesome. So you put people in the lab. What's their division? 50-50. Why? Because it's fair. Fair is a four-letter word. Where I went to law school, that's the University of Chicago. It is not a four-letter word here, and we need to see why. This goes all the way down, ladies and gentlemen. We have got a problem, which is that treating people unfairly is a major source of deadweight loss. Try it with capuchin monkeys. There's this amazing set of studies in which capuchin monkeys love them some cucumbers. They do. They love cucumber slices. And they will happily be trained to and perform a task for cucumber slices again and again and again. Until you start providing grapes to their neighbors for doing the same task. Now, cucumbers are cool. Grapes, oh. And the cucumber capuchin monkey will be like, no, I am now on strike. Until I get grapes, y'all can, We can talk about why that is, but I will say this now. The urge to be treated fairly as a human within a group is far more fundamental to our long-term survival as an individual and as a species that no amount of economic bullshit will ever dig that back out. Oh, as an interesting aside, when they actually ran the ultimatum game, who picked the 99-1 split? Who said yes to it?
People who studied a lot of economics.
Yeah, it turned out it was the econ majors that took the split. Humans didn't. And I say that for a reason, because I'm about to turn you a little bit, I'm going to do some brain damage to you, and so will this institution. I will turn you partially from a human into a lawyer. Don't get high on your own supply. Don't believe this stuff as anything more than a set of frameworks for argumentation to persuade and convince judges and maybe help the world be a better place. But do not believe any of this stuff is absolute gospel. It is not. Rely on your human instincts. If your gut is telling you something is immoral and wrong, follow your gut. Don't follow this crap. All right, so that's enough on economics. What I needed you to know out of this is two things. I need you to know about consumer surplus. Everybody got it? I needed you to know about deadweight loss. And every time a trade that should have gone through doesn't go through, God pops a balloon. With me, therefore? I need you to know one more thing. There's a kind of efficiency that they'll talk about. Economics is supposed to be about efficiency, and this is the weirdest one that people are like, what does this really mean? There's a kind of efficiency that most of these people, including Judge Posner, use. There's a different kind of efficiency that we may end up using later on. The kind of efficiency that they are all going to use, and that is the dominant kind of efficiency, is this. Remember, the goal of economics is not to care who gets the 99 or who gets the 1. The deal is, all economics cares about is that the deal goes through because everybody was going to get richer. That's the only thing they care about. That is called Pareto efficiency, where P-A-R-E-T-O, efficiency. It's the state of affairs that makes an economist happy inside. It doesn't make capuchin monkeys happy inside. It doesn't make humans happy inside, but it makes economists happy inside. It is the state of affairs in which the economists can say, everybody did get more wealthy and no one got less wealthy as a result of this trade. That's called Pareto efficiency. You can obviously notice that there is another form of efficiency out there. We will reference it sometimes. Pareto is mostly what you need. There's another kind, it will come up, and that is this. I need my car, right? I do. I need my car. It's, by the way, and I say that, and you're going to laugh, because I'm going to talk about my car a fair amount. It's a Ford C-Max. They stopped making them for a reason. These are battery-operated hybrid cars where the battery basically dies after a couple of years and you're left with half a gas engine. It's a good time. That said, is it worth more to me or is it worth more to you? If you're embarrassed to answer that question, is it worth more to me or is it worth more to Jeff Bezos? It's worth more to me. Under present earning circumstances, is the car worth more to me than it is to you? It is not. Can you see that it's worth more to me than it is to Jeff Bezos? Can you see that it's worth more to you than it is to me? Interesting. That's a little bit weird. So there's obviously a kind of efficiency that says what we ought to do is take my car and give it to you. You can see how that causes all kinds of problems. We'll run into that. It is a form of efficiency. It's called Kaldor-Hicks efficiency, Kaldor-Hicks efficiency. What it means, it's going to your question, like, are there some times where we do make one person worse off and another person better off? And we know that we're doing it and we still enforce the contract? Yeah, there are. A lot of times it's when there's a promise that needs to be kept, but other times it's beginning, like they'll never admit it, but it begins to be this idea of Kaldor-Hicks efficiency. That what we think is we're making the world a better place by moving the resource from the person who values it less to the person who values it more. Yeah?
So like a zero-sum like transaction?
Well, it's a negative sum transaction, but the problem is that because it's worth more to the person who receives it, actually society as a whole is a net plus. Like I do, and we don't need to go into the state of these cars, but I do actually, so I have a Ford F-150, 1985. If anybody wants it, let me know. It does not drive. There was a grinding noise and I smelled something very strange and that engine is gone and I need to do it. I've got, my youngest drives what's called Little Red Relic. It's a Honda Civic. There's a Subaru that my second kid drives. My wife's got a Prius and I've got the Ford C-Max. There are 5 cars at my house. What does that mean with respect to the value of any given car to me versus to you? I'm not bragging, these cars are wrecks, but yeah, there's just, like, it's less valuable. I have more of them, right? And so you can see how, like, then you have somebody who needs a car desperately to get to work, and you could see how taking one of my cars and giving it to them, preferably one of the ones that drives, and that's only 3 out of the 5, taking some of these cars and giving it to somebody who desperately needs it does make the world, it makes them better off by more than it makes me worse off. But because those evaluations, because those subjective evaluations are impossible to make, how much do I actually value a black border Black Lotus in Magic the Gathering?
Do you still play?
At this point, it wouldn't matter so much if I still played. I do from time to time, although my brother's got a weird mutant variant.
I mean, for collectors, it's worth a lot.
For collectors, it's worth a lot, but that wasn't my question.
Probably not worth much to you.
Yeah, you have no idea. Key to the course, what's the only way that you can possibly actually know what it's worth to me? Cash on the barrelhead. If I say yes, you know, do you know how much? If I say yes, I'll buy it from you for $5,000. You know what about me? And what about the price? It's worth at least $5,000. You still don't know what it's worth. This is the point I'm trying to drive home. You still don't know what it's worth. You just know something you didn't know before. By the way, if I turn it down, you know that it's got to be worth less than $5,000 to me because I didn't say yes. Right? So you know those things within a broad range. Here's my point. Courts get really nervous about Kaldor-Hicks efficiency because it requires them to evaluate the subjective valuations of people for things, and that's something we can't do. And so courts will stay as far away from that as they possibly can, even while doing it secretly and quietly. Because they are making the world a better place, to be clear. It is a form of efficiency. But they can't know that they're making the world a better place. And of course, both parties are standing in front of the court saying, oh, but I super want the car. And the other court's like, no, but I will die without the car. Just like, dudes, how can I tell what it's actually worth to you? All right? Any questions on the economic stuff? What I need you to know is consumer surplus, the trade theory of contract, deadweight loss, Pareto efficiency, and if you want for a bonus round, it's shadow, it's opposite, Kaldor-Hicks efficiency. All right. We're going to get into the case law here in a minute. That's been a lot of theory. We're going to get really down to brass tacks. I'm going to show you how to get down to brass tacks in the law. I will, however, start with one word of additional caution. When we go through a case, if you are looking at a case to find a principle of law that you will write down in your notes to put on your outline and use on the exam, you will be sadly disappointed. That is not why the cases are in the book any more than it is when there's a case profile of a patient in a medical textbook. What kind of patient is never in a medical textbook? You won't find one? A healthy one. Can you see how that changes the whole beeping study? We're studying cases. What I need you to understand is that because we are studying cases, something has already gone horribly wrong here. There is a fundamental disagreement about what the nature of the law is, or at least a willingness to fight it. Both parties have a perspective. We are studying pathological situations, just like medical students study pathology in human bodies. We are a study of pathology, and sometimes that means we can lose sight of what's healthy. So when I say the following thing, which is what you're going to need to do as a lawyer, is find the ground truth that is going to get the court to rule your way, and then give them the legal words they need to cover doing that. The reason you can do that on both sides is the following statement. It's very airport book pseudo-philosophy, but I always found it useful. The opposite of a small truth is a lie. The opposite of a big truth is another truth. That is, our job here when we look at these things is not just to establish, to distill a point, the correctness. It's to say, I can win this case no matter what. You tell me this is the law? Sure, I'll just go over here. You tell me this is the law? Sure, I'll just go over here. I'll just figure this out. All right? So don't be too concerned. Now, when we look at cases, and I wish somebody had told me this in law school. Anybody want to take a guess why cases are in your book? I'll ask, usually, by the way, this will be the point at which I ask someone that I have drawn a random card for. Usually at this point I will say, so why is this case in the book? So listen up. The discussion we're about to have here is the first thing you're going to say on a range of different cases. Why are these cases in a book? There's a bunch of different reasons. Just throw out reasons they might be in the book.
Because as lawyers, we're going to have to read case law, so it's good practice for us to...
Right. So one, we're going to have to give you practice reading case law. And I'm of the opinion that the next gen bar is of the opinion that what we need to do is phase a lot of this out and move you towards practice questions. So we say, here's your cause of action. Here's your claim. What's the first thing you file? That's the kind of thing they want to be on the bar exam. I think that's going to be a real mistake because when we talk about AI, right, it's going to be the structure of law that separates an actual lawyer from a sort of stochastic parrot, a set of word garbage just coming out of nowhere. So nope, we're absolutely going to need practice sorting these things out. In doing that, though, you're going to notice a real problem as a new law student. You have no idea in these cases what's important and what's not. I look through them, I don't even see 90% of the words. I know what it's about. You don't, and that means that you're on full take, that every word has equal impact. You're like, what does this mean? Do I need to know this? First of all, just ask me, do I need to know this? The answer will overwhelmingly be no. No, you don't. Here's what you need to know. So it's not just a matter of learning to read cases, it's also training your eye to extract the things that are going to matter to a lawyer and won't matter outside that. By the way, those turn out to be very, very different things. The clients are going to have a huge... Why is it that the worst fights in family law are often, they're about children, those are the worst fights, but the second worst fights are about dogs? Why are the worst fights about dogs? Second worst fights about dogs. Because that's what's important to the parties. Do you think the fact that it's super important to me is a legal argument? No, we see this all the time. What's driving the case has zero, nada to do with legal doctrine, right? We got to know this. We got to know, no, the dog's actually really important to me, to my client, so I have to win this. But you're not going to be like, Your Honor, we should win because the dog's super important to my client. That's not a legal argument. So we're going to have to fit these two things together. We're going to read the cases, extract from them what's important, and then figure out how to use that to get our clients what they actually need. And those are not at all going to be the same things. All right. What else is a case in the book doing? What else is a case doing here? Yeah.
Showing you the history and evolution of the ideas.
Absolutely. Remember, we are a common law jurisdiction. What that means, and this is a common law subject. The law of contracts changes decision by decision, year by year. It is not the same as it was when I started teaching this class. It will not be the same by the time you are attorneys, judges, or one of you are teaching this class. It will be profoundly different on that. And so oftentimes, and this is actually usually the case, when we come to a new unit, as we are coming to a new unit, the first cases you will see, free participation for anybody who internalizes this and then says it later on, because I will ask you at the beginning of a new unit, hey, why are we reading this case from like 18 what the hell ever? And your answer is going to be because it shows us not where the law is right now, but where it started so that we can watch it mutate and evolve, so that we can see its path. Because knowing the answer to a question, useless. Knowing the path of the law and where it's likely to go is everything. Right? So that's what they're doing there. A lot of them, especially the old, early cases, are there to anchor us, not in what the law is. Dear God, help me. Do not go with like one of these ancient British cases and be like, the rule in the United States is that. That is not the law anymore, and that's the point. The fact that it's not the law anymore, in fact, it's often the law right now is often the exact opposite of where we started. I mean, like all the time, it's the exact opposite of where we started. So don't come in and start quoting, like Krell versus frickin' Henry, which is a disastrous case. Don't start coming in and quoting Krell versus Henry to me, because that is absolutely not the law. Not really, not in the modern sense, but they are there to show you a path so that you can watch it over time. What else are cases doing in this book? Yeah.
Applying like theory and legal jargon to real life examples.
Yeah, so that's that fit we're talking about, right? We got the set of facts, but then we've got this framework, right? By the way, the single worst thing you can do as a young lawyer, practice tip, when your client comes in and sits down across from you and they start telling you their story, what is the single biggest mistake you can make? Open your mouth. Yeah, interrupt in any way. Why? Because you're going to want to interrupt. You're going to be like, oh, that sounds like offer acceptance and consideration. So I'm going to bear down on this as a contracts case, and I'm going to start fishing for facts that help this be that. And it turns out it's going to be a quantum Merowit case or promissory estoppel case. These things that look like contracts but aren't. We're going to go through them in this class a lot. There'll be things that look like contracts and aren't. And so you're going to start pressing it down. You're going to call it a contract theory. The court's going to be like, yeah, but there's no consideration here, so no contract theory for you. Shut up. When your clients are talking, get a pad of paper out, take down everything. Leave the framework for later. Be a human for a minute. Set aside the law and listen to them and ask questions a human would ask. Then you go back and try to fit this framework in over top of it. So it's an excellent point, right? There's this very strange and it's almost like by accident fit between the facts of the world out there and the legal theories that we're going to be using. And fitting that together is a pretty damn big deal. Now, what these cases are not there to do is to show you, oh, I'm going to get these facts and this is the legal answer. One, I'm not going to ask you that on the exam. What I'm going to ask you is something slightly different from the question that we've seen already. And that difference probably makes a difference in your analysis. And so you need to say, this is like that case, but that's different, and because that's different, I can do this with it. That's your move, right? So they are there to help us fit legal frameworks to facts, but be aware that that fit is pretty loose and needs to be pretty loose. And that what they are not here to do, there's like 3 cases in here where I will say, actually I was wrong. This case is here because it is so famous that it stands for a simple legal rule, and here's the simple legal rule. Everything else is here because we're having these conflicts and we need to work them out. All right? Those are basically why cases are in your textbook. There are a few other kinds of cases. They are generally not in private law textbooks. There are other cases that are in the textbook which are because they're anti-precedents. They're simply so disfavored that they count as sort of the opposite of a precedent. Like if you were to do that, it would be like this case. And we can't do that. We know we can't do that case. But we don't see a lot of those in these books, but they're out there for your other classes. Any questions about why we study cases? We study cases because the questions are important, the answers are not. What we're going to get out of these, which is a fit of theory to the framework and the different ways you can pull these things back and forth to win whatever case you've been handed in front of you. And that turns out to be a fairly precise set of answers. So ask me if you're not clear after a case what we were supposed to get out of it, and I'll just tell you. All right. Any questions about that before we get into Lucy versus Zehmer? All right. Well, let's do it. I'll ask for a volunteer just in case, in a minute, not now, but in a minute. I will ask for a volunteer if somebody feels like it. Just remind me of your name and I'll note it down and add participation for it after the class. What we'll do is just, I'm going to ask you, if you do volunteer, I'll ask you what's up with the case. If nobody volunteers, I'll either like randomly pick somebody or I'll figure something out. But I'll just sort of ask you a few friendly questions about the case, and then often what will happen is I'll invite someone else to come in because we need to develop the other side. And usually I'll ask the person who started and gave me the case which side of the case they want. And then I'm going to ask the other person, okay, cool, you're opposing counsel. Let's start doing this thing, which is develop the other side of the case and start showing the strength of the side that lost. You never want to be the party that lost. The most brutal description of one of my articles one time was, this sounds like a brief for the losing side. I was like, damn, oh, that's smart. Happens a lot. You never want to be that in court. You don't want to be that in court, but what you do want to see is the strength that the other side had in the case, because that actually turns out to win in a lot of other cases, and so that's going to be your superpower. And then we'll go back and forth. My goal is to lecture way less than this. We'll see. I like to hear myself talk. And so the question is then, can we kind of get a back and forth going between the two people involved and any co-counsel who want to get stuck in on either side? So that's broadly speaking how we will address these things. Any questions about that before I ask somebody to set up Lucy versus Zehmer? Okay. So would anybody like to volunteer to set up Lucy versus Zehmer? Go for it.
So Zehmer is an owner of a farm, and Lucy wants to buy that farm, and so he meets Zehmer at a pub and brings him one to two drinks, and offers $50,000 to buy his property, something that he's done in the past, but Zehmer has always refused. Zehmer then admitted that it was a good price. They talked for 40 minutes, and then Zehmer expresses doubt that Lucy can pay $50,000. And so in order to prove that he can, Lucy said, Lucy told Zehmer to write a contract saying that I can't afford, that Zehmer would be willing to sell it for $50,000. And so Zehmer writes it down and writes down his intention to sell. He brings it over to his wife after Lucy asked him to, and his wife originally says, I don't want to sell, but then allegedly Zehmer says,
I like that.
allegedly Zehmer says that it's a joke, but he doesn't tell Lucy that. And then so the wife signs, and then they bring the contract back to Lucy, and he puts it down on the table, or he hands it to
Right.
Lucy. We don't know exactly which one. And then Lucy offered $5 to close the deal.
So glad you brought that detail up. That'll be important.
And Lucy, that is when Zehmer realized that Lucy was being completely serious. But they had already signed the contract, and Lucy had every intention of following through with it. And so he, in the next couple of weeks, sets up with his brother to pay
Right.
$50,000.
Right. Okay. So there's so much to unpack here. There's a lot of road to go. That's what I love about these cases. See, because to me, each one of them is like this perfect jewel that shows you the whole class in one case. And Lucy versus Zehmer is absolutely one of these. Let's start with my standard question. What's this doing in the book? What is this case doing in the book?
It's trying to establish whether intent matters or whether outward expression is what's most important.
So, and that is correct. When I ask, why else is it in the book? That is not a statement that that's not the most important. This is our statement of the objective theory of contract. I hope you all have now internalized that the opposite of a small truth is a lie. The opposite of a big truth is another truth, right? Do we think that if the rule were subjective intent, the case would have come out the other way? No, we do not. Why do we not believe this guy for a split second?
Because if you did, then anybody could get out of any contract by just saying that.
There it is, right? It's not even a fact about the case. It's just a fact about life. And it's kind of funny, a bit of an aside. I was doing some work in bankruptcy court, and I realized that the other side was pretty correct on their interpretation of the law. There was some slip. There was one additional step they needed, and they didn't have it yet, but they were going to get it. And but what I said to the court was, if you rule for them, you're out of a job, Your Honor, because bankruptcy courts will cease to exist because everyone will go to state court instead of bankruptcy court for these questions. Now, is that a legal argument? No. Did I win? Yeah, all day long, right? All the way to the end. The court was like, oh yeah, the entire reason for my field will go away. Not cool. Similarly, if we let this go, we don't believe this guy for a second. By the way, what fact has no legal bearing as a matter of legal doctrine? None. What fact stands out on the fact that we do not think this dude means it at all? We don't know his internal intentions. Except we might. Anybody notice?
I remember it being written, he apparently verbally agreed to sell the farm some years prior.
He did this before. He did this before and backed out of it. And the reason he was able to back out of it is a doctrine you don't know yet. It's called the statute of frauds. It means that certain important, not all, certain important contracts must be in writing, not to help them exist, but to help them be enforced. And so if you didn't get it in writing, and it turns out land is one of those important contracts that needs to be in writing to be enforced. So he'd agreed, and he'd backed out on a technicality before. This guy's got a pattern of doing this stuff. All right. So I just want to make the point here. This case is about the objective theory of contract. It's about a few other things, but it is about the objective theory of contract. And also, though, we can begin to see why we don't quite think that's entirely true, why we think something else is going on here, that even if the court were like, no, I'll go with the subjective meaning with what you guys really meant, I just don't believe you in court right now. I think you're lying to do what you did last time, which is to make a deal and back out of it. I think you just made a deal you regretted, and now you don't want it. And we can't have contract law if we do that. Full stop. All right. I'm going to open this up to co-counsel, although you feel free to answer this if you'd like. But I'll open this up to all of you. What else is this case doing in the book? Yeah.
It is providing a very clear, layperson contract. Even the book says it's literally the most bare bones possible contract.
Right.
So it's kind of in the book that teach you the very staples of a binding contract.
Right. And a staple of a binding contract, and also the source of law. Now, this is a bit of a weird one. I'm going to use some words that are easy for lawyers, but that's because lawyers have forgotten the ambiguity in them. This is our black letter law case. What the actual hell does black letter law mean? Anybody want to take a shot? Because I know what it means as a lawyer. It's a signifier in a network of meanings, and I know where it lands. I know how other lawyers will react to it. But if you dig down, I have no idea what it means. What does black letter law mean? Anybody want to take a shot? I hear it a fair amount. Yeah, go for it.
I don't know.
Yeah, no, I don't either, so go for it, yeah.
My understanding is maybe that it is kind of like established, such fundamental law that is baked into the fabric of how we see it today.
Right, there's a fundamental principle baked into the common law. That's what black letter law is. It is not the same as, but it is highly and closely related to what source of law? Because this is the second thing we're doing with Lucy versus Zehmer. We are introducing where to look in your statutory supplement. Where are we looking in our statutory supplement right now?
I thought you were going to say that it was common law.
I am going to say that it's common law. It's common law. Black letter law is established common law. We can find that in cases, but the problem is that some of you, in fact, will be practicing in Virginia, and so I suppose Lucy versus Zehmer may be of some use to you, but look, let's be clear, most of these cases are going to be from completely different jurisdictions and will establish rules different from the rules that will be in your jurisdiction. So what's going on?
Is it the restatement?
The restatement. So the restatement is what happens when you take the common law and then you lock a bunch of academics like me up into a building with way too many recreational substances, and then we try to bring the law together and say, this is a restatement of all of this common law. It is a really useful handbook, but it is not the common law. In some jurisdictions, they will say, we follow the restatement approach. Great. In some jurisdictions, they will say, we don't follow the restatement approach. That's common law too. So this is a confusing set of rules. You've got the rules that are set out in the case, but they apply to that jurisdiction, period. It is not generally a great rule unless I tell you to do it, to write down the rule of that particular case exactly as it's written and then think that's the way things work all across the 51 jurisdictions of the United States. Just no, right? But then there's the restatement, which is largely born out of our need to draw a paycheck. Because our problem is this. We have to teach you common legal rules in a system that has 51 jurisdictions on a bad day, right? So, and the rules are not the same. Like, we kind of hide that from you, and the bar examiners just lie to you. Like, they just lie. They say there is an answer. Look, A, B, C, and D are all right somewhere in the United States, right? So this is a function of the national law school system within the United States. We have to teach as a national law school. That means there have to be a set of principles that we as lawyers pull together to create this framework in our mind. That's what black letter law is. It is common law sourced rules and questions that have made it into the common language of our guild, of our profession, so that we talk to each other as if these things are real, and because we do that, we make them real. Hi, welcome to What Law Is. It's a consensual hallucination where we make things true by acting as if they're true. Also money, right? So that's what law is in this case, and that's what this case is doing. That's the second function of this case. The first function of this case is to introduce you to the objective theory of contract and its problems. The second thing it's doing is it's giving you the first cut you need to make on every single question on my exam questions, which is this about shit you can move or anything else? Now, is this case about shit you can move or anything else? Anything else. This is an anything else case, which means it falls under the restatement. If your answer is, this is about shit we can move, and literally it gets this crazy, is this shit we can move? Is this shit we can move? Unbolt it, yes. That's the difference between this and that, right? The stand on which the laptop is standing. That can be moved. Right now, this cannot. This is, legally speaking, considered part of this building. Somebody forecloses on this building right now, they take this with them. Somebody forecloses on this building right now, they do not take this with them, they do not take that with them, they do not take that with them, although for a number of different reasons, right? There is a huge division in this class, a division so huge that I hope to see many of you next year for the upper level course, Article 2 Sales. But we are going to do a lot of it in this class because that is a lot of what the modern law of contract is the industrial system of moving stuff you can move. So the first question you should ask for any case is this about stuff I can move or is it about anything else? Land is anything else. Service contracts are anything else. The basic economic trade is dollars for stuff or dollars for services. If it's dollars for stuff, ask, can I move the stuff or can't I? If I can move the stuff, we use Article 2 Sales of the Uniform Commercial Code. That's one of the reasons why you need this bad boy, because Article 2 Sales will be in here. We use Article 2 Sales of the Uniform Commercial Code. For anything else, we use the common law, and our major source for the common law, although it itself has a weird relationship with common law, and is in fact not the law until a common law court says it is. I know that's really confusing, but until a court says, we adopt, let's try this. One of the major rules we will study in this class, we haven't yet, we haven't seen it yet, you will, you'll dream about it, I'm sorry. It's called Section 90 of the Restatement. Section 90 of the Restatement, promissory estoppel. Oh boy, we're gonna have a moment. But here's something. Virginia does not recognize Section 90 of the Uniform Commercial Code, the Restatement. Sorry, not of the Uniform Commercial Code. It does not recognize Section 90 of the Restatement. There's no such thing as promissory estoppel in the state of Virginia. Okay, so it's got this weird relationship. It'll be a touchstone, a way of reminding us of these common law rules, a way of seeing the big trends and the categories that reach across the states. But check your jurisdiction. They are not the actual law until a court says, we follow the restatement approach in this jurisdiction. Okay, then that's law. Then that's the real deal. So that can be a confusing thing when you're looking at a case. I need you to know what law you're looking at when you're looking at the case. If you can move it, what are you looking at? Article 2. If you can't move it or you can't touch it, then common law. And there it is. That's the whole deal. Some stuff for things that you can't touch, but like there's copyright involved. We'll touch very briefly on that. That is a whole other kettle of fish. Catch me in property next semester or in the upper level classes on those. All right. So that's the second thing that this is doing in the book. Are there any other questions on this before we move on to NIPSCO? Because I'm going to have an easy question for whoever sets it up, which is what is this doing in the book? And all you got to do is just repeat the last 2 minutes of what we've been saying, and you win. But are there any further questions about Lucy versus Zehmer? I guess I have one further one. What do we make about his argument that he was drunk?
We don't buy it.
We don't buy it.
The wife specifically said that he was not so drunk that he couldn't drive Lucy home if needed. So.
Right, and we don't buy it. We don't buy it, asterisk, like you came with receipts. Love it.
Yeah, I think the standard was like,
By the way, yeah, what law am I, yeah, I love this. What law am I going for here?
what law?
Yeah,
Sorry, like,
because there is a legal principle here. I know we haven't seen them yet, and this is totally unfair. But first of all, where is this likely to come from?
from whatever state you're in, their intoxication laws.
Their intoxication laws as routed through their response to the restatement, right? So what's the idea here about being drunk?
That if you're not like utterly disabled, then your contract still counts.
Then your contract still counts. Why are they worried about that? Being incapacitated by different uses of things is a defense. It's called a capacity defense when you're on the bar. This is a capacity defense. You do not have the capacity, as we're about to introduce the big C word of this class, which is the most controversial and problematic word of them all. Why would we permit a capacity defense? Why would we say, yeah, if somebody's just passed out at a table, you can't like grab their hand and make them sign shit?
You must be able to understand or comprehend the nature and consequences of anything you
Yeah, you must be able to understand the nature and consequences of the thing you said. Why?
That'd be avoidable contract if you couldn't comprehend it.
That's the result. Although, by the way, whoa. How many of y'all have bought something online in the past 2 weeks? Cool. How many of y'all understood the contract you signed when you did that? Because you did sign a contract when you did that. Oh, shit. So we have some views. You're right, and yet, right?
You must be able to consent.
You must be able to consent. That's the big, bad word. Because contracts as the law of bargain for exchange means that the parties both understand and consensually enter into a bargain. We will see how contract law has become the opposite of that in every way. Who has clicked I agree in the last month? Okay. Lower your hand if you actually agreed. I mean, I usually even say it. I'm like, no, I don't agree, but like you have to. The law of bargain for exchange has become the law of mandatory extraction because these contracts have been stapled to our bought and paid for digital goods, and we have no choice in order to use the things that we fully bought and paid for and need to function in the society. We have no choice but to agree to things that we've never agreed to, that we do not comprehend, that we've never read. And by the way, if we tried to read them, a friend of mine from over the hill actually did a research paper on what he did was he bought a new computer, and then he just printed out every end user license agreement that popped up when he turned his computer on and used it for a few minutes. The stack of paper was about this tall. You think people are reading that? You think people can read that? What we're talking about is here a system that is philosophically fundamentally founded on a concept of consent that then it immediately turns around and lies and lies and lies about creating. Among other things, do not apply the concepts of consent you will study in this class to any other area of your life. Because they're going to start saying things like, you were aware there was a contract, so whatever's in it, you're bound by. That's not what we do in when you get consent for a medical procedure. That's not how any of this works. And so when you hear the word consent, it is the law of consensual agreement, the law of bargain for exchange. It does over time become its exact opposite, where we're not really entering into bargains. We have no ability to change the terms of the contract. They are forced on us, right? But as we see that shift back and forth, we have to keep an eye on this question. Consent is going to be the biggest problem that we've got in contract law by a long shot. We can't do without it, and it turns out we can't really have it either. All right. So, having said all that stuff, let's turn to NIPSCO, and we will continue with next readings for next time. Can I induce someone to give me a presentation on NIPSCO? Go for it.
So NIPSCO is a utility company. They entered into a 20-year contract to buy coal from the Carbon County coal company. The contract allowed for one-sided negotiation, so if the price of coal went up in the market, then the price of coal in the contract could go up, but it could not come back down. So NIPSCO essentially bet that the price of coal would either stay the same or go up. They'd be locked in at their price floor, but then if it came down, there would be a big loss. They were losing money. They wanted to raise rates on their users. I forget what it was called, but the commission didn't allow them to raise rates unless they made a good faith effort to buy energy from elsewhere. They were able to buy energy from elsewhere, so they would have to do that, but they would have to continue buying the coal as well. So they tried to use the economic purchase order as a point of frustration and excuse themselves from the contract.
Right.
Carbon County sued for breach of contract, and then eventually they both appealed. NIPSCO appealed the decision, and Carbon County cross-appealed for specific performance fulfilling the rest of the contract because the mine had closed in the industry.
Okay, amazing, amazing. And there's a lot here, and you've hit all of the points. I was just kind of ticking them off in my brain as I was going. So I want to tell you what you should take notice of, but not worry about quite yet. First of all, as with all of these cases, because they're fully formed cases, you just said a bunch of words we're not going to study until the last week of class, or in between sometime. This class, generally speaking, follows the following path. We will discuss contract formation. We will discuss contract formalization. We will discuss contract interpretation, defenses, and remedies. Now, before I ask you what the hell is this doing in the book, I want to point out this case is mostly about a defense, the defenses of frustration of purpose or of impossibility. And yeah, you should write those down, but you should write them down to remember in 10 weeks' time when we go through the defenses of impossibility and misunderstanding and a bunch of other defenses that are going to go, coercion, right? We're going to go through a bunch of different defenses at that time, and that's where we're going to do this. And I'll say, remember Lucy versus Zehmer way back? We actually did this the first day of class. But I don't expect you to have that fully integrated right now. I just want you to know that all that stuff is there. Also, specific performance. It's really important for us to understand what specific performance is to understand why Judge Posner was like, no. But we don't get to specific performance until literally week 12 or week 13, because that is a remedy. That is what you get at the end of a case. So when I ask you things like I'm about to ask you, what is specific performance in this case? I want you to understand, this is a profoundly unfair question. I am asking 12 weeks early. I just have no choice. That's because in order to get to the foundational stuff that the case is doing in the book here, we got to understand the nature of what they're asking the court to do and how it relates. So what's the nature of the remedy? End of the course, specific performance. By the way, just to save your brains, you do not get specific performance in contracts. You do not get it. The rule is this: you get specific performance for unique and irreplaceable things. Land and Picassos, and anything that attributes that's unique like land or Picassos. That's what you get specific performance for. You never get a court order for specific performance. Can anybody tell me why?
Because usually specific performance is in cases where damages
I don't fulfill the contract.
Yep. When damages are insufficient, we use specific performance. Specific performance is a court order to do something. It is a court order to perform the contract rather than to breach it and pay damages. Now, there's some reasons why we think deep in our history that contracts disputes are fundamentally economic. They're not. But they're fundamentally economic, at least in our theory, and that means that money damages are considered, most of the time, completely okay. And so you can never get them, unless it is like a Picasso, where you're never gonna see that Picasso again. Like, you can't just go get another Picasso and then like sue for money damages, right? It's unique. So that's when you get specific performance. You get those court orders. What's the court order in this case? The court order to perform the contract. What would that look like?
It would mean that NIPSCO would continue to have to buy coal at the $44 per ton limit,
Right.
and then Carbon County
Right.
would have to keep producing the coal at a cost of $20.
So why not do that? If we think that contracts should be enforced, I think broadly, there are problems with contract law, let's be clear. But if we think that broadly speaking contracts should be enforced, well then, okay, why not actually make people perform? Yeah. It's inefficient. That's why the judge does it. What happens if the judge orders this contract to go through? There's dead weight loss, right? What happens? Every lump of coal takes how much money to get out of the ground? Make up a number. Okay, so every lump of coal takes $20 to go. You guys value coal a lot more highly than I do. Every lump of coal costs $20 to get out of the ground, and you can sell it for, make up a number.
$30?
That's not his problem here. $5. That's his problem. That's his problem. He enforces this contract. Every lump of coal that comes out of the ground and God pops a balloon. The world gets worse. Everybody gets poorer, right? Because we have dead weight loss. We have a loss of money. This is simply a sucking chest wound at the center of our economic system. There is no way in hell he's going to enforce it. That's why he's doing this. What he does is a matter of manipulation of black letter contract. So there's a couple of things here. First of all, what kind of law are we under here? And I'll open this up to co-counsel. We've had an excellent exposition, but feel free to answer as well as if you'd like. Yeah. Article 2. Why? Cool. Going to keep pressing you on it. Why is this a movable good? You're right. Keep going. Coal is moving from Wyoming to Indiana, and then you will run into this. Although if I tell you the truth here, you're going to unlearn everything you learned about Lucy versus Zehmer, because I'll just confuse you beyond thing. What's the problem with treating coal as a movable good? Anybody been down a coal mine? It's a natural resource. It's not like, it doesn't start movable. Like you gotta harvest, right? Like I just said under the law of fixation that this is part of the building and that's not, and that's the difference between a movable good and not. And yet when you encounter coal in its initial state, it's more like that than that. I know, the law doesn't care. In fact, the law cares even less. Remember Lucy versus Zehmer? It turns out if you buy land with the timber and you say you intend to cut the timber for the timber to be cut, then that can be a sale of movable goods. Same thing with livestock. Article 2, you think you know what movable goods means? You don't, so I'm going to tell you a few things that are going to be on the bar exam that are going to confuse you about what movable goods mean. Movable goods means coal, it means water, it means your water utility, it does not mean your electrical utility, because somehow we move water and we do not move electrons. I swear to God I can't make this stuff up. And it covers timber it is movable when you have timber to be cut, livestock to be sold, or crops that have not been harvested yet. Those are all still goods, and those are the ones they put on the bar exam because they're jerks, and because they know if they do this, you're gonna be like, that's good, Professor Fairfield told me that was good, so that's good. So this is in our book to show us our second big set of law. Restatement for everything else, Article 2 for stuff we can move. Can we move coal? Yeah, we can. Just remember, they will ask you on the bar about water. I swear they will. They have a thing for it. They can't stop. They're like, ooh, water's the perfect example because it's like kind of different. Oil. What law do we use? UCC, absolutely, right? This podium. Yep, hang on. It was a relevant question. Nope.
It's on a blocker.
Oh, it's on a blocker. Love it. So it's locked. And it has wheels. All right, you see, right? This is a good. Can I move it? No, but like I could. Except, theoretically, apparently I'm not really showing up here. All right, you guys get the point. This is about our second big set of laws. Now we have one final thing. We know why the court did what it did, because it's inefficient and because it's creating deadweight laws. We know what law we're looking at. Now we're looking at something again that we will not return to until about week 12 of the class, where we will study defenses to the performance of a contract. And some of the defenses that we will study will be frustration of purpose and impossibility. Now remember how far down the course we got to get in order to get there, and this is where we're going to stop. Remember how far down the course we got to get in order to get there. We have to say, you have formed a contract. We have interpreted the contract. We know what it means. You formalized the contract. You did all the bells and whistles, the dances to make sure the court knows, yes, we are intending to be in a contract, because that's important because you're creating law that just applies to the two of you. You need to tell people about that, right? So we formalized the contract. We then get to defenses, right? So we've got a minute till we get there. What are the defenses that we see here? Force majeure, which is nonsense. What is force majeure? By the way, your right answer. What is the reason why force majeure is? You write in your contract, hey, if there's a blizzard, or if there's nuclear war, or if there's a worldwide global pandemic, which nobody put in there prior to about 4 years ago for some strange reason, or an alien invasion, that in those cases we do not have to perform the contract. That's force majeure. Why does that not apply to this case at all? Well, right, because they're claiming the government's force majeure, and that, by the way, can be true if the law changes. An unexpected change in law can be the force majeure, but there's another reason why.
In the case they talked about how the government wasn't stopping them from using it.
Yeah, the government's not stopping them from doing it. One, so it's weird to use government as force majeure. You can in some cases, but two, it's not even opposite. By the way, it's also not force majeure because they didn't write this down. They wrote the opposite down. Did they write down in their contract what happens if the price of coal falls? No. Did they write in their contract what happens when the price of coal goes up? There's no way in the hell the court's letting them get out of that. And we got to talk about that. There's one last thing. We are at time, so I'm going to let you go. There's one last reason, and this is where we will pick up next time, that this case is in the book. Notice that Lucy versus Zehmer is a one-time sale. One and done, the parties walk away. This is a long-term contract. And these have fundamentally different characteristics where you are making bets about prices and goods over 20 years. That is a completely different animal. And they have a completely different set of rules around it. We'll pick that up next time. Thanks so much, folks. Great class today. I'll send around the agenda and let people know if you're on deck for next time. And if you have any other questions, please feel free to see me after class. We'll go through them. Thanks so much.